Hi, warriors. This is Jaylyn, my legal warrior, and today we have a special guest, Mackenzie Colt, and she is an employment law attorney. And why don't you go ahead and, introduce yourself a little bit further?
Hi, good afternoon. Thank you so much for having me. So I practice private civil litigation in the area of employment law. Now our firm does defense and plaintiffs work in those areas. And so I've been studying this COVID issue because it's one of the things that we do predict after the crisis is over, that we're going to see an uptick in employment cases being filed. And we want to make sure that our clients are protected or they're asserting their proper rights in these matters.
Okay, fantastic. Yeah, of course. Everything on the news, at least on my Facebook feed, and so everything that I'm
Right.
reading is about different employment rights. And now all these different laws are coming
Mhm.
out ever since the quarantine. And so one of the big terms that's being tossed around is essential employees. So, what is an essential
Right.
employee? Who is that? And what are their rights?
So the term employee is coming down from the governor's orders or from the executive orders that were issued by the president earlier in March and early April. Basically, an essential employee is somebody who provides something along the supply chain for essential goods or services for individuals in the public. So generally speaking, the list of essential employees that are in the governor's order of California from earlier this month included anybody who's working in the food supply chain. So farm workers, people who are doing shipping, trucking for those types of industries, anyone that works at a grocery store, food delivery, those types of people. But then it also includes any type of emergency workers or medical personnel. So those who are on the front lines that we're thankful for every day, they are considered our essential employees. It doesn't necessarily protect all essential employees, however, for being able to keep going to work. The OSHA guidelines that were issued earlier this month do try to encourage businesses to reduce their staff where possible, even when they are an essential business.
Interesting. And you use the word OSHA guidelines. What is that?
So currently OSHA has put out a guideline recommendation, which I'm providing you with the link for so that you can check it out. Unfortunately, this is not anything that is statutorily binding as to determining who is an essential employee, or as to what needs to be done for those essential employees to be considered safe. But it does give a list of guidelines that if you are an employer, that you should try to stick to in trying to keep your employees and the public safe in providing services.
Okay. So if somebody was an essential employee, but they don't want to go into work anymore, can they actually qualify for unemployment?
Well, that all depends. Currently, they can apply for unemployment only if they actually are terminated from their job or put on work furlough. So really the issue comes down to, if you're going to voluntarily quit or stop working during this time, what are your options? Generally, under the new guidelines and under the California Family First Act, you can use paid sick time if you qualify under their guidelines for COVID-related issues. Now, this would include individuals who are 65 and older, immunocompromised, somebody who's taking care of individuals that have any of those issues, parents who need to take time off to take care of their kids who are now being stuck at home. And those people would be protected under getting sick leave. Now, if an employer chooses to not create a safe working condition, so prior to April 9th, there was no enforcement of mandatory masks like at grocery stores. And so we were actually getting a lot of calls from employees who said, well, I don't want to go to work. Can I stop working because they're creating this issue? And thankfully, the governor did address this, because now there is a mandated mask requirement for anybody working in an essential job. Now, with that said, you can get paid sick leave, employment insurance if you qualify under the guidelines. Now, if you just quit and there isn't really a reason to, I think the best thing you can do is try to work with your employer first. If they are not doing things to make you feel safe to be at work, you always could try to You can always try to unionize or collectively bargain with your employer. One way to do that would be to, get them together, come up with a list of demands to make you feel safe at work, and then go from there. And OSHA actually does discuss this in the regulation and the new regulatory guidelines that they put out, and the fact that absenteeism is going to be going up. And how do you deal with that? Because people don't feel safe sometimes. And what it really comes down to is that fear of safety rational or irrational? Do they have good cause to take off of work? So where an employee quits or decides not to go into work and doesn't have paid sick time during that time, they can apply for unemployment insurance, but it has to be with good cause.
Got it. And so I've also heard this term hazard pay. I don't even know if that's a legal term or if that's just something that people throw out there. But can an employee get hazard pay?
Right. And that's, you hit the nail on the head right there. It's not necessarily a legal term. The only time that it's ever addressed is in federal labor law, and it has something more to do with if you have a physically demanding job in the type of job where you're going to be working over hours, then it has to be included in increased overtime benefits. But there's no such thing as hazard pay as far as it being required by your job. Now, getting back to, like I said, if you want to organize, you would be protected under national federal law for labor organization to try to demand better wages. Mm-hmm. And there seems to be somewhat of a revolution, or at least there was for a minute, where you started to see workers demanding more job security and more hazard pay, or that term hazard pay, mm-hmm. or more pay for the type of work they're doing. But right now, it doesn't really seem like the national conversation is getting back to the idea of demanding better conditions or better pay. And in my opinion, these frontline workers really do deserve it because they are putting their life on the line in order to provide us with living conditions for us to be able to sit at home. And those people deserve, they definitely deserve more increased pay.
Yeah, 110% agree with you. So what is characterized as an unsafe working condition?
So an unsafe working condition would be an unintendable, unreasonable working condition in regards to health and safety. So if you are if your employer is causing you to work in an area where you don't have 6 feet in between you, you're not being given proper PPE equipment, in general, these really unintendable hazardous conditions, that would be considered an unsafe working condition, particularly in relation to COVID-19.
You use this term PPE, and I've actually seen that term several times over. What does that stand for?
Yeah. Personal protective equipment.
Gotcha.
And this is something that's actually been required anyway for certain hazardous types of positions, like people who work in, the obviously medical industry that might perform surgeries, or people who have been body art practitioners, people who do tattoos. Those people have always been required to wear PPE. And so that falls under, OSHA regulations for safety and hazardous material type, or jobs where you might be exposed to hazardous materials. And so that's always been part of it. Now it's just being suggested that under the federal, it's being suggested that it be more widespread. Obviously, under California, our governor has now mandated that this is part of what they expect employers of essential businesses to provide.
Interesting. So it sounds like even though we already have certain regulations in place, they weren't necessarily strictly enforced.
And a lot of that comes down to, as well, just if you're going to have a business that's going to somehow affect the public safety. So if you're dealing with food handling, you're dealing, like I said, doing tattoo art or doing, any kind of medical procedures, those have always, had, different regulatory bodies that require certain protective equipment, or the other term that the other thing that you need for them is you need a plan, basically, like a hazardous material plan for any of those types of issues. Mm-hmm. But the close nature that people come into contact at a salon, I do understand that. One of the other things that I've seen is there's been some stories too about how salon workers have been going to houses to perform work. And, you think about the wide range of age groups that a salon worker might deal with, the fear of them spreading, the virus could be increased. So
yeah, yeah. I kind of run through that scenario in my mind, and I'm just like, I wish I could do it. I wish I can actually have somebody come and at least, do my nails during this time.
right.
But I don't think the risk is
I did see someone as a hairdresser who was doing, she was shipping, high quality hair dye, and then she would do a tutorial like on Zoom for her clients,
Mhm.
which I think is pretty cool, but I'd still be really nervous that I'm not going to do it correct. So
I'm with you on that as well.
at the same time, I am so fortunate, and I hope that other people have gotten the opportunity to take advantage of the unemployment benefits that our state has offered and the supplement from the federal government. Unfortunately, I have heard from a number of people who applied after April 9th that they still haven't heard back in the last 3 weeks. There's also the people who were applying for unemployment benefits who were independent contractors or self-employed, and our state has still not set up the ED website for those individuals. It says on their COVID resource page that they would have it up by April 28th, but it doesn't seem, we'll find out tomorrow
Yeah.
on that issue. So
Yeah. It's interesting. I mean,
so hopefully,
I personally, did apply for the PPP, and I think I did it within like 48 hours of me even learning about it, or before it even, went on the market and stuff, and haven't heard back. And I'm just kind of twiddling my thumbs like, it is what it is. Or what can an employee do if their rights are violated in terms of employee mistreatment during COVID-19?
right. So there's a few ways that their rights might be violated. So they have a right as an employee to demand safer work conditions. Okay. So one area you might see them suffer or is through retaliation. So if they're fired for, trying to get better working conditions, safer working conditions and related to this, and they are fired, you can file a retaliatory complaint with the labor board or the labor board office here in California. And just to be aware, you do have only 90 days to file it. So it needs to be something that you're on top of if you are having those issues. And like I said, that's for like a whistleblower violation or whistleblower violation. You can also that would be for any time if you're trying to take sick leave, or like I was saying, that you are entitled to have the paid sick leave. If you're denied that, you can always report that as well. If you're denied any kind of, stay at home, being able to stay home with your children because they're having to stay home, that is protected. And so you can file with the labor board to try to get that, to try to have employer fined for that. And then what will happen is there will be a investigation into those issues, and you'll find out as far as those report goes, what, if there's anything for any further steps you can take legally or, in terms of litigation for that.
Let me ask you a final question. So if a parent that is separated from the other parents, or from their co-parent, and now that the children are staying at home, you kind of, touched on that, and they can't actually, they're an essential employee, but they can't go in on Friday during those work hours while the children are at school, and the other parent also is in the same boat. And so from what I'm understanding from you is that they can, in fact, apply for unemployment, or what procedures would that person need to take if that parent is in that scenario?
So if they are staying home to care for a child who's been advised to sequester, yes, they can apply for unemployment, or they can get sick leave. However, like I said, these regulations seem to be coming out and changing almost every other week, because as of 2 weeks ago, the California, and I mentioned on the forums earlier that you could apply to be an essential business. So they did include childcare workers as individuals who could apply for still providing childcare to essential workers. So there could be an argument eventually against that they can't. However, I will say this: it doesn't seem like EDD is really enforcing the individuals for quitting their job right now.
Okay.
It seems that they're kind of doing a blanket, providing. And that really comes down to if EDD calls your employer and says, hey, was this person did they voluntarily leave their job? Well, that employer is really leaving themselves up to some liability.
Right.
Because then it's going to come down to, well, do you really want to litigate the issue? If the person does, challenge what their employer said, a lot of times employees will get upset and they might try to file a wage and hour claim or an unsafe working condition, basically where you're forced not to work. And so is it a risk that you're willing to take? I understand that employers don't want to end up being, flipping the bill because they're mad at an employee, but you have to measure what your exposure is in that type of situation. So
Yeah. Very interesting. Well, thank you so much for all this information. And if individuals wanted to get a hold of you to consult with you, what can they do? Is there like a phone number, email, social media handles?
Yeah, you can. Yeah, so we're in Hillcrest in San Diego, just next to downtown. We're part of the Arena Law Group, and our phone number is 619-231-3100.
All right. And they would ask for you specifically, right?
Yeah, so I handle the civil litigation issues as far as the employment cases go for our firm.
Okay. Fantastic. Thank you so much again for, collaborating with me on this.
Thank you.
I've definitely learned a lot.
Yeah. All right, take care. Thank you.